An act to amend the Criminal Justice Release from Custody Special Provisions Act Cap C40, Laws of the Federation of Nigeria 2004. Mr. President, distinguished senators of the Federal Republic of Nigeria, I thank you for the privilege to lead debate on the general principles of this bill for an act to amend the Criminal Justice Release from Custody Special Provisions Act Cap C40, Laws of the Federation of Nigeria 2004. The bill was read the first time in this hallowed chamber on the 8th of November 2012. The thrust of this auspicious bill is to address, with the hope of finally laying to rest, the nagging national issue of prison congestion that has defied almost every regime and attendant administrative policies in this country. The disheartening bleak truth is that our prisons host almost 70% of inmates who are awaiting trial, a worrisome fact considered by our Minister of Interior, Abamoro, and globally echoed and lamented by Amnesty International. The agonizing statistics which our Minister of Interior admitted recently revealed that 30,000 or over 65% of over 46,000 inmates of prisons across the country are awaiting trial. Distinguished colleagues, we are all aware of the various efforts by past governments in this country to tackle this thorny national issue to no avail. These measures culminated in the inauguration of an intervention fund of 8.723 billion naira under the supervision of Federal Ministry of Justice in 2006, which fetched no tangible result. It is instructive to note that this multinational issue is not new to this hallowed chamber. The Senate leader, Senator Victor Ndomaegba, SAN, representing the Senate President at the public hearing held at Senate Conference Hall Room 022 on Monday, 2nd of April 2012 said, and I quote him, "The condition of our prisons is an indictment on our penal system and goes contrary to the constitutional guarantee that an accused person is presumed innocent until found guilty by a competent court of law." He lamented the situation whereby awaiting trial persons are kept in prisons more than the time they ought to have spent if timely sentenced. Emphasis mine. The myth is that the CJN or the CJs of the various states do the entire nation a great favor by their annual ritual visits to the prisons to release detained inmates who have languished for many years behind the bars. Hence, the traditional encomium in the media poured on the few chief judicial officers who ventured into such annual prison rites, usually at the beginning of the legal year. However, the incontrovertible fact, my distinguished colleagues, is that this bill sought to be amended mandates the CJN and chief judges of the states to release inmates whose detention is, in quotes, manifestly unlawful, or have, again in quotes, overstayed their presumed prison terms while awaiting trial. Therefore, what we have on our hands is actually a statutory obligation and duty on the part of our chief judicial officers that should reduce the suffocating flood of prison congestion due to awaiting trial inmates. This enactment, which we hope to amend, is an unassailable two-section legislation which came into force since 8th of March 1977. May I, at this juncture, distinguished colleagues, and with kind permission of Mr. President, cite the provision of Section 1 of this short principal act. It provides for the power of the Chief Justice and the Chief Judges to order release of persons detained in certain cases. 1. Where, in respect of any person detained in any prison in Nigeria, not being a person detained in execution of a sentence of a court or tribunal duly constituted by law, the Chief Justice of Nigeria and the Chief Judge of a state is satisfied that A, the detention of that person is manifestly unlawful, or B, person detained has been in custody, whether on remand or otherwise, for a period longer than the maximum period of imprisonment which the person detained could have served had been convicted on the offense in respect of which he was detained. The Chief Justice or the Chief Judge may issue an order of release to the officer in charge of the prison, and such officer shall on receipt of the order release the person named therein. Also emphasis mine. The plank of this proposed amendment is to revive and strengthen this 35-year-old act by now making it mandatory for the Comptroller General of Prison, as the Chief Custodian of Prison Inmates, to timeously send a monthly return of the entire inmates of the prison to the CJN and to the Chief Judge of the relevant state. The Chief Judicial Officer shall, on the basis of this return, order the release of inmates who fall into the category covered by this act. The foregoing provision is in contradistinction to the hitherto once a year if the Chief Judicial Officer chooses to exercise the power at all. This statutory provision will not only decongest the prisons considerably, but will also ensure official record keeping, inject sanity, transparency, and guarantee timely review of a crowded and frightening prison system. Distinguished colleagues, the subject matter of this amendment bill hinges on the fundamental rights as enshrined in the Constitution. The Constitution of the Federal Republic, as amended, via Section 35, subsections 4 and 5, categorically provided that accused must be brought before a court within a reasonable time or be released from custody between 2 and 3 months, depending on whether it's subsection 4 or 5, from the date of the arrest. Therefore, this disturbing detention of persons is tantamount to an infringement of their fundamental rights as ordained by our Constitution. As senators of the Federal Republic, Mr. President, our constitutional standard and oath of office is to protect, defend, and preserve the Constitution of the Federal Republic as amended, and upon which we called on God Almighty to help us. It is cardinal to point out that holding a person awaiting trial beyond the time he or she would have spent had they been sentenced for the offense they have been charged is a matter viewed globally as infringement of their fundamental rights. The overpopulation of the prisons have largely been responsible for the incessant jailbreaks in Nigeria, and with this comes the attendant security risk to our nation, as both convicted and awaiting trial inmates disappear into the thin air. The beauty of the cumulative effect of the extant act and the proposed amendment is that the CJN or the chief judges of states do not have seamless or limitless latitude to just release persons awaiting trial at his or her whims and caprice. It is based on condition precedent, to wit, a person whose detention is patently unlawful, or a person who has exceeded the term of imprisonment for which he or she is accused. These instances are too ample in our system. In the latter instance, for instance, the person awaiting trial would have completed, in any event, the term of imprisonment for which he or she has been arraigned. He or she has nevertheless been punished. He or she just has not been convicted or formally sentenced. It is important to note that the intended amendment is without prejudice to the proposed amendment to the Prisons Act, Cap P29, Laws of the Federation 2004, which is a wholesale reform of the administration of prisons in Nigeria. If anything, it will serve to complement the prisons reform process. Section 3 of the amendment bill purports to amend the concluding phrase of Section 1.1 of the Principal Act, only to the extent that it replaces the officer in charge of prisons with the controller of prisons. This is to ensure clarity and avoid ambiguity, as the controller of prisons is used in the Prisons Act, Cap 29, Laws of the Federation of Nigeria 2004, and not officer in charge of the prison. Moreover, officer in charge is not defined in this act, being sought to be amended. The amendment defines controller of prisons as it is defined in the Prisons Act. Thus, the controller of prisons means the controller of prisons of the Nigerian Prison Services. Section 2 of the Prisons Act is the interpretation section. It only defined prisons as having the same meaning as in the Prisons Act. Bearing Order 77, Rule 3 of the Senate Standing Orders 2011 as amended in mind, the bill has no financial implication whatsoever. Mr. President, most distinguished senators, I am hereby re-echoing that godly call for us to support this bill and salvage ourselves from this embarrassing prison congestion malaise that has adversely reduced our international rating amongst the Community of Nations. It is equally a call on our virtues and values as human beings, as well as a benchmark on human liberty. I thank you very much.